As you might guess, Tokyo Mart was a specialist supermarket in Sydney selling Japanese groceries. One of the products they sold was seaweed. These days, we understand that Japanese cuisine uses many different types of seaweed, but back then, things were a little less advanced, and so the case merely refers to seaweed. One thing we do know is that this seaweed was sold in a dried form. Sometimes it was consumed dried, but sometimes it was reconstituted with water. The fact that it was commonly eaten in both ways ultimately led this matter to court. Food in New South Wales was regulated by the Pure Food Regulations 1937, which specified the maximum amount of various metals that could be allowed in food. In this case, the concern was antimony, which can be toxic if consumed. The regulations specified a maximum number of milligrams of each metal that could be contained in a kilogram of the food. But then it said, in the case of food in a dried or concentrated form, the concentration shall be determined with respect to the mass of the food after dilution or reconstitution. The seaweed at Tokyo Mart contained too much antimony in its dried form, but it would have been lawful once reconstituted in water. However, the legislative drafter had not provided for a situation where a food was consumed both dried and reconstituted. The court found that the purpose of the statute was very clear: to protect consumers from foods which contained too much of various dangerous substances. If it appeared that words had been left out of the statute inadvertently, and the result was to defeat the purpose of the statute, it was permissible for the court to read the statute as though the omitted words were there. Justice of Appeal Marnie said that where the legislative inadvertence consists not in a failure to address the problem and determine what should be done, but in the failure to provide in the instrument express words appropriate to give effect to it, in this case it may be possible for the court, in the process of construction, to remedy the omission. From this case, we learn that while courts should not indulge in legislation or lawmaking from the bench, the court is allowed to fill in obvious gaps where there has been an error on the part of the drafter.